Hello, and welcome virtually to the Texas Public Policy Foundation. My name is Rob Henneke. I'm the General Counsel and Litigation Director here at the Texas Public Policy Foundation, and we're thrilled to have you join us to have the discussion today about the importance of constitutional protection for parental rights, and specifically to talk about a recent Texas Supreme Court case that has already had profound implications for defending the constitutional protections for parents, biological parents, to their biological and adopted children. And so with me here today is my panelist, who I'll introduce in a moment, is Chris Clay, who's a father that was involved in this historic case, going to give his perspective. Professor Brad Wilcox from the University of Virginia, and then my colleague here at TPPF, Andrew Brown, who leads our work for constitutional protections for parental rights and families and children. So we're thrilled to have you. And, you know, as a way of a brief background, the case was known as In Re CJC. It was a case that was before the Texas Supreme Court. The CJC is Chris Clay, who's with us. And the basic premise of the case was a real tragic instance where Chris had a daughter, and the mother, Chris and the mother were not married. The mother tragically died. The daughter was very young, and Chris is a wonderful father, has always been a wonderful father, and would naturally and did naturally move forward a step in as his role then to be the sole custody, being the only surviving parent. And Chris was involved in a very, very unfortunate parental rights fight where the boyfriend of the late mother sued for custody and actually was able to initially prevail in the trial court, where the trial judge sought to award this boyfriend who had lived with the mother for about 9 months, but sought to award the unrelated boyfriend joint custody and joint visitation with Chris. And so I think, you know, in a heroic way, Chris really stood up for himself and went to the mat and fought this case all the way to the Texas Supreme Court, where the court addressed the issue of whether it is inherent that courts must consider a parent to be fit to have custody, control, and make the decisions for their child unless that presumption is rebutted. There's a standard in Texas family law called the best interest standard, where courts in family law situations are required to give the best interest of the child. And so the question was, is it inherent in the best interest that parents have this constitutional presumption? So we're going to talk a whole lot more about that, but let me first introduce our panelists. As I said, I have with me, first of all, Chris Clay. Chris is, besides being a father himself, he's a parental rights advocate, lives in Dallas-Fort Worth. This lawsuit went on for over 2 years. And as I said, the Supreme Court recently ruled in his favor that affirmed this important constitutional protection for parental rights. I'm also very, very privileged to have with us Professor Brad Wilcox. Brad is a professor of sociology at the University of Virginia, where his research focuses on marriage, fatherhood, and family structure. And in addition to this, Professor Wilcox serves as the director of the National Marriage Project. He's a visiting scholar with the American Enterprise Institute and is a senior fellow at the Institute for Family Studies. Finally, to introduce my colleague here at the Texas Public Policy Foundation, I have Andrew Brown. Andrew is an attorney with me. He serves as the Distinguished Senior Fellow of Child and Family Policy. A father himself, he's a graduate of Baylor University and has his law degree from Southern Methodist University. So, gentlemen, welcome. Thank you for joining us here today. We're going to have a great discussion about this important topic. But Chris, let me start with you. And if I could get you to just give more, detail about your family's history and kind of describe for us how this happened and, really how it impacted you having to have this fight over your own child against, in some ways, a virtual stranger over who would get to have custody and rights to your child. So thank you for being with us, and let me have you kick it off.
Yeah. Thank you, Rob, and thank you to the Texas Public Policy Foundation as well. So basically, just like anyone else, my ex and I, my daughter's mother, we had split custody, so it was close to 50-50, and going through just that process and co-parenting. At the end of the day, regardless of the outcome of my case, the one person that loses is ultimately my daughter. She is without her mother. That is not a scenario that any child should have to go through. And so, that's something that we still work with her. And I am married, so I do have a wife, and she has stepped in to fill those shoes. But at the same time, it's not the same as well. But went through 2 years and still going through the litigation process. And it was challenging. It's challenging to know that someone else could sue you that you don't know and could possibly be given rights to your child, and especially if they spent a short amount of time with them. So going through multiple court hearings, etc., was a challenge. We are glad that the Supreme Court ruled in our favor to protect parents and to also not have any other parents potentially go through what I've gone through. But it has been challenging. It's not inexpensive. It's stressful. It definitely, my daughter could sense the stress as well. So going through this wasn't easy, and it hasn't been easy for her. And my number one priority was to take care of her and get the help that she needed, because she was ultimately the one that this has affected the most. I just think that I needed to do what I could do for her to make sure that she is able to move on and have a life that she can be able to be proud of, and that we can help her and nurture her as best as possible.
Let me ask you, when I've described this case to colleagues and friends of mine and so forth, the initial reaction has just been incredulous, that it would just be, how could you believe that, the courts would step in and try to give custody to a non-relative when you have, a biological parent who already has custody, who already has a co-parenting relationship, who already is engaged and has a great relationship with the child. Tell me about your reaction initially when the trial court violated the Constitution, got it wrong, but went in this direction to split this custody beside yourself and the other man.
It was definitely a shock. You ask yourself, am I, is the judge hearing the same case I'm hearing? Are the facts, what are we missing? I hadn't heard of anything like this before, because I hadn't been in this type of litigation. And it was a surprise to know that, especially in this county, that was occurring. And then you ask yourself, how many other families has this happened to? That, if it happened to me, it's probably happened to others. Just we had the means to continue to fight. The other thing, it wasn't going to be beneficial to my daughter in any way. And we had evidence and testimony to back that up. So once again, we questioned, what are we missing here? What could we have done better? What needed to be presented maybe in a different way? But ultimately, what facts are getting what facts is the decision being based on? And I think some of that was potentially missed in here.
You know, one of the debates in the case, and I think a way that really showed the different perspective with which our side, your side was coming from versus the other side was in the argument about where parental rights come from. And the Texas Supreme Court got it correct. They recognized and affirmed that parental rights are rights that are not granted by government. They're inalienable rights that we have. And if anything, there needs to be, you know, what the Constitution does is put limits on government as far as being able to intrude upon our right. But, you know, tell me a little bit more about the feeling. You're in a court proceeding, and here you have the judge, the government, that comes in through the judicial process to basically forcibly take your child away from you. You know, how did that make you feel as the biological parent of your daughter in this situation where you're supposed to have your rights protected by the courts?
As a taxpayer, I was seeing that it was judicial kidnapping, and it was almost, is my money being spent in the best way as a taxpayer? And on the inside, you're angry, you're upset. You know, my father, and for any father or any parent to go through this, your emotions are already high as is, and you're trying to hide them. And this is my only child too. So, but it's disappointing. It's very disappointing. I don't envy judges for a lot of the decisions they have to make, because I would not want to be in that position. But at the same time, they're in that position to make difficult decisions. And as a public and as a resident of the county, we hope that they're making the right decisions. And so that's kind of where my faith relies on them, and to see this and be there and know that deep down we knew that this was a violation of my constitutional rights, and to see it happening and to be going through this, it's almost something that you read in a book or you hear someone else tell you about it, and you say, that can't happen. But it was happening. And so it was definitely hurtful. And like I said, I don't envy the position that judges are put in, but I just hope that my case will help judges make better decisions and protect other Texas families as well.
Andrew, let me turn to you and kind of explain where the foundation fits into this case and how we became involved.
Sure. During the summer of 2019, Chris's attorneys actually reached out to see if we'd be interested in filing an amicus brief supporting his position when they filed their appeal with the Texas Supreme Court. One of the areas that we focus on, that I have the blessing to be able to work with on the foundation, is the fundamental rights of parents and protecting that most important institution in our society, the family. So because of that work, Chris's attorneys reached out to us, and when they presented this case, I mean, I think you and I both had our jaws hit the floor, just because it was so shocking what was happening to him and the injustice that had been done. So in that sense, the decision to get involved was very easy, because it was abundantly clear that the trial court's decisions violated Chris's constitutional rights as a fit parent. And then beyond that, it presented the opportunity not only to correct the wrong that was done in Chris's life and in his daughter's life, but then to help restore some critical constitutional protections for families that over the years have been slowly whittled away by different court decisions. So we thought this case was so important that we filed our amicus brief almost as soon as we saw that that Chris's attorneys had filed their appeal with the Supreme Court, with the hope that the court would see how important this case was. And fortunately they did, and granted oral argument. And as you said, they got the decision exactly right.
So in Texas, Andrew, tell me what you see that this court decision is going to have in terms of family law practice and parental rights here in the state.
Well, as we've already seen, you mentioned earlier, the Court of Appeals down in Corpus Christi has already reversed a previous decision that it made prior to the Texas Supreme Court's ruling in CJC, and they directly cited to CJC when they reversed their decision. What I think this case does is it provides really critical clarity around just how important the rights of fit parents are. One of the main cases that we cited in our arguments to the Supreme Court is a U.S. Supreme Court case called Counsel v. Granville that was decided in 2000. And in that case, Justice O'Connor wrote that parental rights, the right of a parent to direct the care, custody, and control of their children, is perhaps one of the oldest fundamental liberty interests recognized by the United States Supreme Court. And what's important about Chris's case is it really builds on the foundation of Counsel and, quite frankly, over 100 years of both Texas and U.S. Supreme Court precedent protecting the rights of parents and the relationship that parents have with their children. And by building on that, we will probably see courts, and what I hope happens is we will see courts being very careful about interjecting themselves into the private decisions made by parents, and really protecting this fundamental principle that it is in the best interest of children for the fit parent to be the primary and sole decision maker for what's in the best interest of their child and not have those decisions second guessed by the state.
Professor Wilcox, I want to extend this conversation beyond just a specific case and a legal background and kind of put it in the greater context of the importance of a family to a healthy society. At one point, I know that I saw a statistic that estimated that 50% of marriages end in divorce. And where children are involved or without children, but specifically in that context of a parent, the divorce proceeding puts the government involved. And so as unfortunately divorce continues to be a common occurrence in modern families, what is the importance of this case and this concept in the context of the interaction with families and the government?
Great questions, Rob. What I would want to just begin though by mentioning is that we actually have good news on the marriage front. So since 1980, divorce has come down pretty markedly in American life. And so what that means is that today, my colleagues estimate that only about sort of 39% of couples who are getting married today will end up getting divorced. And so we actually can have greater confidence as a country and as a culture in the ways in which marriage today stabilizes family life, for our kids especially. At the same time, in fact, this obviously is very germane to this case we're talking about today, we are seeing about 40% of kids being born outside of wedlock. And those kids are much more likely to experience family instability, to experience kind of a carousel of partners coming in and out of the household. And that kind of family instability is not good for kids. And this is why this case is so germane to our, to our larger kind of cultural conversation, family life in America. So what I'm suggesting is that I think that the concern here is how can we as a culture and how can family law both on the one hand strengthen marriage and on the other hand kind of minimize the amount of instability, the sort of the number of parents and partners and adults that our kids are exposed to. And we know in particular that kids are more likely to be physically, sexually, and emotionally abused by unrelated adult males. And so I think, as we're sort of looking at cases like the one today that Chris has mentioned, sort of has brought to our attention today, we need to be thinking about, do our laws and do our court decisions take into account the risks that unrelated adults, especially unrelated males, pose to our children, and make sure that we're trying to again give kids the most stable environment, minimize this partnership go around that we see in parts of our society today, And then also, and finally, kind of pay attention to biological relatedness. And, a lot of people probably are reluctant to sort of acknowledge this, but it is the case that there's a very strong, literature indicating that kids are most likely to flourish with their biological parents. And so again, as we're thinking about cases like Chris's, the law and our judges should take into account, the relatedness of the adults in terms of making determinations about child custody and, where kids land in the wake of a breakup or a divorce or a death.
Well, thank you for that. And also to clarify a point I made earlier, which is related to this case too, Brad, you're exactly right. With so many of children born out of wedlock, it's not only when you have married parents that have a divorce, when you have children, and if you're not married, the courts are still involved, because just as Chris had with the mother of his daughter, you have to go to court to get a custody arrangement, to arrange for child support and all of that. So in all of these situations, not just where you have married families, you're in the, where you have the need to define these roles and responsibilities, then that's where the courts get involved, which, is, seemingly always necessary when you have a child born to parents who aren't married. But I want to kind of stay on the topic that you said. I mean, your research has demonstrated what we, I think, inherently know. Children are better off when they grow up in a married two-parent household, but that's not always the reality or the possibility. And so when you have a situation where you have a single parent, what is the importance of that child being raised by a biological parent? Why is that significant as opposed to any, good adult, any moral adult, any solid
Sure.
citizen you could just pick and pair with a child? What does your research show us is the importance of this biological relationship?
Well, and again, in responding to your excellent question, Rob, it's important to acknowledge that, today kids confront a variety of family situations. I was raised by a single mom, and kids can thrive in a variety of contexts, but it's still the case that there's a large literature indicating that that kids are more likely to thrive when they're being raised by biological parents. And I think, the story there is, is derived in part from the lessons we learned from evolutionary psychology, something about kind of kinship that tends to reinforce a sense of connection and identification with the child when you have biological kin who are caring for that child. And so, adoptive parents obviously can and do step up and do a great job oftentimes, and step parents often step up and do a good job as well. But it is the case that, that biological tie tends to give parents an advantage when it comes to raising kids. And it's also the case too, when we kind of switch our perspective from the parents' viewpoint to, or the adult's viewpoint to the kid's viewpoint, that kids are more likely themselves to identify with an adult as a parent when that adult is their biological parent. And by contrast, when it's a step parent or an adoptive parent, when things get difficult in a family, as they always do, when there's disagreements about curfews or, chores or other kinds of things, kids are much more likely to sort of say at some point, you're not my dad, you're not my mom. And there's more often, kind of a certain kind of friction that can develop around the fact that the parent is not their biological, kin. So that's a point that's also worth thinking about here in all of this.
Well, thank you for that. And I'm going to start now with a more of a discussion with our group because I want to jump to Chris, but then come back to you, Brad. Chris, how would you describe, if you could describe this situation through the eyes of your daughter? And I know that this has been going on for a long time, but and your daughter was very young and is very young already. from her perspective, how do you think she saw this? And how do you think, she saw the conflict, and what kind of aid and discussions or how you tried to help her with her young mind understand what was going on here and how that affected her?
Yeah, excellent question. And I've gotten this several times from others on, what did you do? The best thing that we did was we tried to, as much as possible, to keep her in the dark about any of the litigation. The litigation involved her grandparents on the maternal side as well. And so we didn't want that to have any impact on her relationship with them. So we really just focused on her. We got her counseling because at a young age, the mind's still growing, and we got her into a counselor that specializes in child trauma, and we're able to get her in there so that she can express her feelings in different ways, and that we can be aware of that as well. So outside of that, we provide her structure, caring, loving household, and but we also were there because it's going to come up. I miss my mommy. It still does come up. I miss this that I had when I lived with my mommy. And so we have to be aware of that, and also be aware that when she is grieving in a different way, because we all do grieve differently, and we got her the help that she needed. We've been that shoulder that she could lean on, cry on, express her feelings with. And so from her, it's challenging for her too, because I wouldn't want to be in that situation. But we did try to give her as much help and support immediately up front as possible, so that she can grieve the right way, grieve, and with us knowing it, and how she's going to express her feelings as she grows. So she is now 6.
So to pivot off of that and come back to you, Brad, Chris mentioned the word trauma, and that's a word that's not yet come up in our discussion, but I think it's a very appropriate word, and I understand the context of the therapy that was sought for Chris's daughter. But, in the basis of your research, can you expand on the consequence to children, the trauma that we're talking about, that this is not just a legal fight, the injury that's caused, and why these protections exist because of the trauma consequences that result from even sometimes the most amicable types of custody divisions?
Sure. I think if we think about kids, if we've had children, if we've taught kids, if we've babysat for children, we know that kids thrive on stable routines with stable caregivers. They just really kind of gravitate towards stability in terms of schedules and people and everything else. And so the challenge today is that a lot of families can't give that stability, or have difficulty giving that stability to kids. So one of the challenges, I think, is trying to both in law and in culture, obviously culture being more important really in all of this than law, is reinforcing the importance of stability. And of course, the best way to do that is through marriage. But failing that, it's important too when we're talking to single parents and working with single parents to just kind of recognize or help them understand that when it comes to kind of their own lives, and when they begin dating, if they do begin dating, that stability is really important for their kids, and that if they're going to be moving into a new relationship, it's important to kind of move slowly and make sure that that person, that partner, is has good character, and has their best interests at heart, and eventually has their kids' best interest at heart. But unfortunately today in our culture, some parents move in and out of relationships on a fairly quickly basis, and in so doing often unintentionally put their kids at risk, both of kind of, having their kids, build an emotional connection, with a partner in the household, or even obviously more sobering, put their kids at risk of being, neglected or abused by that partner. So this is where the idea of trauma comes in. It's traumatic for kids to be exposed to a kind of relationship carousel where there are different, caretakers coming into the household. And it's also traumatic for them, obviously, to be abused or neglected when this kind of family instability is playing out. And so this kind of trauma can lead kids to have attachment difficulties. It can lead them to be anxious, to be depressed. And these are more common for girls, and then for boys, they're more likely to act out, when they're exposed to this kind of trauma in the home.
So to put the period on the point of this, in many of these historic cases, in this case, Chris's case, in the Troxel case, where you had a custody fight between grandparents and parents, in those instances, courts have erred when they've put all of the parties on an equal footing. And in the Troxel case, the U.S. Supreme Court recognized a fit parent presumption for biological parents that applied in the context of a grandparent seeking custody. That fit parent presumption was the issue in Chris's case before the Texas Supreme Court. In this context, we're talking about a legal definition, but how to, close the loop for me on how your research shows that the science supports the legal premise of this fit parent presumption applied to a biological parent.
So, the basic idea here is that when it comes to providing financial, emotional, and social support, and when it also comes to kind of reining in your temper or anything else that can be harmful to kids, on average, and of course we know that there are exceptions, and that's why kids are, for instance, taken into, care of child services, for instance. But on average, we know that biological parents are more likely to invest in their kids, and they're also more likely to, to avoid problematic behaviors related to, abuse and neglect, because of the fact they have this kind of kinship tie that is connecting them to kids. So that's sort of, I think, the point that we could draw from a lot of the sociology and the psychology and the economics of the family.
Andrew, coming to you, and Brad, I think you articulated that very well. What was surprising in this case, everything that we've discussed here today, and certainly supported by Professor Wilcox's research, is to me inherent. And yet we had groups on the other side that filed amicus briefs seeking to have the opposite outcome. And specifically, what surprised me is that you had a liberal family law group, loose affiliated with the State Bar of Texas, that filed on the other side, advocating for the court to ignore this fit parent presumption. Within the context of family law and the different sides, did that surprise you? And where is the attack on parental rights coming from, as represented by these groups that don't want to recognize the legal and natural importance of biological parental ties?
Yeah, that's a great question. And it did surprise me to an extent in this case, just because when you look at the pure facts of it, it's very, very clear. Chris is a fit parent. The common sense solution that if we walk down the street, 99 out of 100 people that we asked would say, yeah, absolutely. If the mother of the child passes away, then the fit father should be empowered and able to make the decisions and be the primary caregiver of that child, free from interference from outside parties. In that sense, it was shocking. It wasn't shocking in the sense of when you look at where family law is going, and I think a lot of this stems from what Professor Wilcox highlighted in the breakdown of that traditional nuclear family over the years, and these various custody arrangements and the merry-go-round of partners, and even when you have relatives that are chipping in to help raise a child, what we think of as the family has become a little bit more complicated from a cultural standpoint. And what that has done is it's opened the door for a lot of creative lawyering and cases where in Troxel, it was a dispute with the grandparents, where the grandparents wanted to have primary custody over the child. In this case, it was a non-relative former live-in boyfriend of the child's deceased mother that wanted to have a relationship with the child. And it was particularly interesting that Chris earlier mentioned that the maternal grandparents were involved. They had earlier petitioned for visitation rights to the child, and the court actually threw the maternal grandparents out on a standing ground, which developed out of the Troxel decision. That, however, did not apply to the former live-in boyfriend. And so basically, from our reading of the case, the judge was able to do this end run around the Troxel decision and Texas law to essentially give the grandparents access through the former live-in boyfriend. And that has to do with some variations in the way that the Texas code worked in this case. But when you have attorneys who are making a good living representing grandparents and representing non-relatives in these custody disputes, I think you create an environment and built on some of the cultural confusion that's going on, in which some of these wild decisions can get made that, as I mentioned earlier, really do whittle away at the core foundational principle that it is in the best interest of children to be raised by their parents in nearly every circumstance.
So before I ask my follow-up question, just want to make sure I mentioned to the audience, if you have questions, go ahead and post those to the Facebook thread, and we'll bring those forward and have those for discussion. But Andrew, in this context too, and I think this also relates to the work that you've been doing in reforming child protective services, you do have a large group of individuals that really believe that government is the better caretaker and for making decisions about raising children, and that clashes with where we are now. I know that Chris's case had nothing to do with child protective services. They weren't involved at all, nor should they have been. But where so much of family law and child custody involves not just a judge making a decision about your child, but the judge doing so because the government has come in to try to take away your parental rights or to take your children. How does this friction between the view of a default having a fit parent presumption versus the view that the government knows better than you how to be a caretaker, how did you see that played out in this case?
It played out in a number of ways. I think most obviously with the trial court's decision to say it was in the best interest of Chris's daughter that Chris not be the primary decision maker in her life, that he not be the one who makes the decision as to how much time she spends with her maternal grandparents or how much time she spends with her deceased mother's former boyfriend, if at all. And for the court essentially to substitute its own judgment for that of Chris when it comes to his daughter is a product of the way that the state has kind of evolved and developed in its stance toward parents and in its stance toward parental rights. There is obviously a role for government to play when children are in imminent danger of harm or have actually been abused. The problem that we're seeing, though, is government is inherently reactive, and especially with child welfare departments, they don't want to be on the front page. And so they are looking for any opportunity to inject themselves into this realm of the family. And I think we've seen that even over the last several months with some fairly notable scholars advocating for, a presumptive ban for homeschooling. There are other legal scholars out there who have advanced more radical positions of getting rid of the legal parenthood, the assumption that if you have a child, you are that child's legal parent, and requiring parents to essentially prove that they're fit before the state will actually recognize them as their own child's parent. And like I said, that is a very radical position that's been put forward that I think very few people take seriously. But it is a product of the perversion of this idea that communities can come together to support families, and the government has essentially stepped in and pushed communities aside, and places of worship that traditionally were the places that families could turn to for help if they were in crisis. And the government has essentially shoved them out of the way and injected itself to say, no, we know what's better, we can help you. And in doing so, have fundamentally undermined, I think, the health and well-being of countless families across the country.
Brad, to follow up on this point, I would say historically before the 20th century, when you would have a tragedy where the parents of a child or children would be killed, that what I would think would typically happen would be, the neighbors or whoever would find a way to take those children and they would connect them to the next of kin. They would drop them off at Aunt May's house, or they would go, find some other biological relative, and they would deliver the children, the orphan children. Government wasn't involved in that. That's just how community took care of community, and how that would occur when you had certain tragedies, with the community assumption being, the importance of keeping children with family, and the assumption that family would take care of children. But now we have the administrative state. Now we have, in every state, we have these massive child protective services bureaucracy. We have the welfare state. And yes, we would all agree that there are instances of abuse or neglect, or there are instances of poverty where government has an appropriate caretaking responsibility, but it is much bigger than that. And how would you say that the growth of government in our society and its involvement in the family, in children, in parents, during the past 100 years is contributing to some of the problems that you see in the destruction of the family as the basic unit of society?
Yeah, well, I think what's happened really in the last 50 years, Rob, is that the state has taken a much larger role as a kind of, second parent for kids and for families. And so what that means is that we depend less upon marriage. We depend less upon fathers in particular. And we also have seen ways in which there's been a kind of a marriage penalty emerging since the 1960s, where when couples are kind of considering whether or not they should just live together as a cohabiting couple, or if they should marry, there's often a way in which the financial incentives line up in favor of cohabitation rather than marriage. I was talking to a couple here in Virginia a little while ago, two beautiful kids, about 4 and 6. And, they've been together for a while, but they were not married. And I asked them what was going on there. And they said, well, we sat down at the kitchen table and we kind of ran the numbers, and we realized that we wouldn't have access to Medicaid for the mom with 2 kids, were we to marry, based upon their household income. And it was coming primarily from the father in this case. So the bigger point here is that some public policies, today, some public policies over the last half century have unintentionally undercut sort of the value and the authority of the family, and also kind of the utility, economic utility of marriage in particular. And so as we kind of go forward here, we need to think about ways to minimize the penalties that the state has, has put on things like marriage with the current, arrangement for our social welfare policies here in the U.S.
That's a great point. Andrew, what's your response to that?
I think Brad's absolutely right. Though, whether it's an intended consequence or an unintended consequence, government policies have disincentivized family formation for a number of years, and we are reaping what we've sown as a society that has approved of that and that has even voted to advance those policies. There are very compassionate ways that we can and should be taking care of those in our society who are struggling and who need a little bit of extra help from time to time. But we're doing a disservice to not just adults, but more importantly, a disservice to children when we're making it more advantageous for their parents to either separate or choose not to marry, or just to cohabitate, rather than engaging in that lifelong commitment of marriage and that commitment to investing themselves in one another and in their children. Speaking as a father myself, the most important thing in my life is the relationship that I have with my wife and with our children. And when we were engaged in discussing getting married, one of the first conversations that we had was, divorce is not on the table for us. Let's just agree right now before we move any further that this will never be something that's an option, both because of our beliefs in the sanctity of marriage, but also in wanting to have children in the future, not wanting to put them through the trauma and the instability of that separation. And to the extent that I think government policies related to welfare or even the way that the family courts approach divorce issues often undermine what should be the gold standard and what has been called the gold standard of the best interests of children.
We've had a terrific discussion today. Brad, Andrew, I want to thank you all for joining us. But Chris, I want to give you the last word as we conclude here. In this case, we argued before the Texas Supreme Court under this weird environment that we're in here today. We were one of the first cases that was actually argued via video before the justices. And as a result, you prevailed, you were represented, but in some ways, Chris, you didn't get your day in court because you were never in that court. You were represented and the case came out in the same way, but part of the personal aspect of court and the open courts doctrines allows you to be there present before the judges who are going to decide cases that are important to your life and our lives. And I want to ask you, not that you would have had a chance to personally participate in that case, but what would your message be to the 9 justices on the Texas Supreme Court that decided this, yes, historic case, but one also very personal to you? What would you want to say to them? What would your closing thoughts to them be about the importance of how they decided this case?
Yeah, thank you for that question, Rob. And we were looking for our day in court, and ultimately my attorney, Holly Draper, she worked really hard to get us to the point and organize different organizations on our side and work with Andrew and Texas Homeschool Coalition, et cetera. And she worked really hard to get there. And so I wish that she had the same opportunity to appear in court that we both wanted. To the Texas Supreme Court, you got this one right, and you got it right all the way. This was a decision that all parents can support. You didn't just get this right for me. You got this right for many other children, many other families. And this type of decision is going to, number one, help protect other families and children, keep them with their biological parents if they are fit. It's also going to clear out some of the lawsuits that may be going into courts for this. And so from a tax paying standpoint, I think we're going to be more efficient with those dollars, and judges now won't have these frivolous type of lawsuits or lawsuits that maybe have loopholes in them to where there is an opportunity that we saw here. So it's a very good decision, and it's one that not only Texans can be behind, but other citizens of the United States. And I think Texas is going to be a shining star with this decision that other states can look upon and say, Texas got this one right. Let's look and see how we can get this right as well for other families. So thank you to the justices for getting this one right. And we appreciate it. My daughter appreciates it. My family does too. And as Texans, June 26th was a proud day for us in the Clay household. That's the day that the decision came down, and we'll celebrate that as a holiday. And I think many other families will also celebrate that. It's very important to us. And so thank you.
Very well said. Professor Wilcox, thank you for joining us.
Thank you, Rob.
Mr. Clay, thank you for being here and for staying with this fight. Of course, Andrew, it's always a pleasure to share the stage, the screen with you. But that concludes our discussion here today. I want to thank our audience for tuning in today. Follow the Texas Public Policy Foundation at texaspolicy.com to learn more about the historic work that Andrew is leading in defending and advancing parental rights and constitutional protections. Thank you for joining us today. And please tune in for the next broadcast as we go through another area of public policy that is changing the lives of Texans and Americans. Thank you for joining us.
Thank you, Rob.